The pertinent statute here, Your Honor, is KSA 6607, which essentially sets forth the proper venue for a domestic relations action. A1 states that a divorce or marriage action may be brought in any county in which the petitioner is an actual resident at the time of filing the petition. The Kansas Supreme Court in Blair versus Blair stated that residence, in this instance, is a place which in good faith would become one's actual residence, regardless of the amount of time that the individual has lived there. On July 15th, or approximately around that date, my client moved to El Dorado. He has significant family history in Butler County and in El Dorado. His parents reside in El Dorado. His sibling resides in El Dorado and have for the majority of their lives. So when there were issues in the marital home, he moved to El Dorado. He moved here with the intent to stay. 45 days after moving to El Dorado, he filed the petition for divorce in Butler County. It's our position that he had established a residence here, that he was living here with the intent to stay here. He had taken the steps to enroll the children in school here. They have attended school in El Dorado since the petition was filed and the temporary order was granted. He has the choice of where to file his case. Butler County and the state of Kansas is a one-party divorce state. So he did not have to notify Miss Farthing of his intent to file for divorce. He filed for divorce in the county of his residence, which is his choice. She was properly served, quickly retained counsel. That counsel stepped away, and now Miss Huntington is her counsel. We think venue is appropriate in Butler County, and we would ask the court to retain venue. The court already has subject matter and personal jurisdiction, and just proceed with this case as already filed.
Okay. Well, I believe with him living, as he stated in his petition at 3156 Northeast Highway 177 in El Dorado, Kansas. I think venue was proper for him to file here with regard to a matter of a convenient forum. Fortunately, with the advent of Zoom proceedings, teachers, other professional folks, we can do hybrid hearings. We can do Zoom hearings. We can accommodate parties so they don't have to travel. I think a lot of times I look at some of these issues as to what could a party reasonably expect. And I think that your client could anticipate, if he's from this area with the majority of his family here, if they separated, that's probably the direction he would go. So it's not as if he just ran off and tried to find a county where he thought he could find somebody would be sympathetic to him for one reason or another, with actually no ties or connections to the community. He has those things. So I think we're far enough down the road that I'm going to deny the request to change or transfer venue today. So go ahead and proceed, Ms. Huntington, with your motion to modify.
Okay, thank you, Your Honor. This case was filed in September of 2024, and in the temporary orders that were granted ex parte, the petitioner moved out of the marital residence, which was over $3,500 or right thereabouts, and the total household expenses were over $5,000, knowing that my client has not been employed for over a year. And he left her in the residence. And those did not get modified in 14 days. So I understand the court's not going to go back and do that. That did not happen. previously. But we are asking for modification of these temporary orders. That was one of the first reasons that we had asked for it. She continues to look for employment. She's enrolled in a program for medical coding, and those classes will be started. But the petitioner knew that she had no income, yet he proceeded in a manner that was not the status quo of the parties, obtained these ex parte temporary orders that left my client in a horrible financial situation. She has moved out of the marital residence at this point, and has moved into an apartment with her 87-year-old grandfather that was also living with the parties in their marital residence. And so she's got out of the house. There's a separate motion filed by the petitioner to put the house on the market, and counsel and I have already spoken, and we don't have an objection to that, and we're in agreement. And I think she may have already drafted an order for my review. But there remains to be a huge disparity in income between these parties. There was no spousal maintenance awarded to my client in the temporary orders. There was child support ordered against my client for $350 a month. But I don't know how that number was calculated as far as what they took into consideration. Your Honor, we are asking that the court look at the domestic relations affidavit filed by the petitioner. He's indicated he makes $6,048 a month. My client has zero income, but even if we impute her to minimum wage, that's approximately $1,257 a month. There's a $4,791 difference in the incomes of these parties. 25% of that we believe is reasonable to look at as potential spousal maintenance. So we would ask the court to order or modify the temporary orders and order temporary spousal maintenance amount of $1,200 a month. The child support, right now the petitioner gave himself primary custody of the children, and that's what it is under the temporary orders. They had the temporary order set at $350 a month in child support. I didn't get it filed until this morning, and I think my staff sent it over to Your Honor. It was a proposed child support worksheet. And if the court were to grant our request for the $1,200 spousal maintenance, the child support obligation to my client would go up, but yet she would have some additional income. So it would be $581. And that, like I said, Your Honor, that child support worksheet was sent over to Your Honor earlier this morning as a proposed worksheet. But in addition to us asking for modification of the temporary orders as it relates to spousal maintenance and child support, we're asking for modification as to custody and parenting time. As I mentioned, Your Honor, in the temporary order, the petitioner has primary residential custody of both of the children. Dane is 14 and Seth is 12. Seth has repeatedly asked to go back home to be with his mom. He wants to return to his to the school that he was attending before. Dane hasn't said a whole lot about which way he wants to go, but my client is asking that custody be modified back to her as primary residential parent. We've submitted a proposed child support or parenting plan that is at Exhibit C in our notebook. This proposed parenting plan would have the respondent or the petitioner with weekend parenting time and then additional parenting time as agreed by the parties. We believe this is in the best interest of the children. That is the school that they were accustomed to. That's where they had friends. They were doing well in the school, Your Honor. I've also attached as exhibits K and L, showing that the older son, Dane, is struggling in school where he's at now. He's got D's and F's in his classes. We believe returning him back to the environment, well, into the school system that he was at in Belle Plaine would be in his best interest. There had been some discussion between the parties about potentially having Seth go back, but maybe not Dane. We're open to looking at those things, but the primary residency being in El Dorado is just simply not in the best interest of the children. I understand the petitioner is probably going to argue that my client is struggling with alcoholism. She admits that she has over the years. There was a domestic incident between the parties that probably was the last straw and led to the filing of the divorce. Both parties have sought and received diversion on that case. There's a separate case against my client with her sister around the same time frame. That case has also been put in diversion, and both these cases are in Sumner County. My client attended Holland Pathways. She went through the recovery program. She completed the program as required under the Holland Pathways curriculum. At Exhibit G, Your Honor, you'll see that my client has a certificate of completion of that program. The second page of Exhibit G is a letter dated October 1 of 24 from Holland Pathways indicating how my client did with the program, that she was extremely involved in the process and working through issues that she was having. They pointed out how the divorce is impacting her and how that's played a part in the challenges that she's addressed. She also goes to the VA and has a therapist there that she sees, and she's on medication, and she continues to follow through with on the recommendations there. She's maintaining her sobriety, and she would like the court to consider all of that. And she's able to provide a safe environment for her children. She has a...
Did you say VA?
Yes.
Okay. Is she a veteran or what?
She is, Your Honor. Yeah. Okay. Yes. And
how long did she serve? I mean, what's the reason for not working this last year?
Well, my understanding, Your Honor, and you can ask my client directly if you would prefer to do that, but that she's been looking for employment. She's been trying to find something. Her history has been in aviation, and I think she's had difficulty getting back into that. Her last job was with Spirit, I believe, and she was laid off or let go from that, and you know, that's her history, is the kind of work that she's done, and she's been unable to find anything replace that job.
All right.
She's moved into a new house in Sumner County in Belle Plaine. It's a 3-bedroom house. Like I mentioned before, her 87-year-old father lives there. He had lived with the parties, and he had provided childcare and assisted the parties when they needed help after work, evenings, weekends, things like that. And he will continue to do so if the children are returned to her primary custody. I know in Butler County, a lot of times you like to send the parties to mediation. My client would be open to go into mediation to try to get this resolved. But we would like something done on a temporary basis to try to get at least the younger child back into the school district that he was in. He's begged and pleaded to go back and live with his mom. The petitioner is well aware of this. The petitioner has not always followed through on the temporary orders in allowing parenting time as was stated in the temporary orders. He's made it difficult for my client at times. The communications by the phones have been shut off, and my client, it's in some of our exhibits, Your Honor. But essentially, she would say, "Why are the phones off? I can't get a hold of them." And he'd say, "That's on them. They didn't charge it," you know, and was not consistently making sure that she had communication with the children. His demeanor with her has been very short. He's called her derogatory names in their communications. Those are also contained in the exhibits that we've attached, Your Honor. So he's not done the best job of being a co-parent. And I understand that these parties are going through a divorce, and hopefully they get on the right track and they can be good co-parents, but right now that's not happening. My client has basically been shut off from her children, left in a situation where she had no income and no ability to pay these bills. And so we would ask Your Honor to take a serious consideration of modification for the reasons that we've outlaid thus far. Thank you, Your Honor.
All right, Ms. Locke?
Sure, Judge, I'm gonna give a little bit of history before I respond to Ms. Huntington's argument. The parties resided in Arkansas previously and moved, Alabama, I apologize, and moved to Kansas about a year and a half, 2 years ago now, and resided in Belle Plaine. They both worked in the aerospace industry in Alabama, moved to the Wichita area to continue that similar employment. There was a history of domestic violence issues, including charges against Miss Farthing in Alabama before they moved. When they moved, this history, and this has primarily been based on Miss Farthing's issues with alcohol, and that was documented in the Alabama case, and then also is relevant to the court here today. In July of 2024, there was an incident involving the party's oldest minor child. He ran away from Miss Farthing's care. He called his dad. His dad said, call the police. He came and picked him up, and then the minor child came and resided with dad for a period of time before going back to the marital residence. When they both went back to the marital residence, there was the domestic violence issue that resulted in charges on both parties in Sumner County. And those case numbers, if the court wants them, are SU 2024 CR 180 and 181. Both parties are on diversion on those cases. However, my client in July of 2024 was told that he could not return to the marital residence. He was to have no contact with Miss Farthing, and that at that time he moved to El Dorado. Ultimately, he ended up filing for divorce. When he filed for divorce, Miss Farthing entered into a treatment program. So there's some argument that she should have been the primary parent this entire time, but obviously she could not be the primary parent when she was in rehab. And Mr. Farthing acted as the primary parent. The kids needed to go to school. He's living in El Dorado. He enrolls them in El Dorado schools, which is obviously a transition for high school and middle school age children. But they're enrolled in school, and I'm told by dad that their grades are improving in this second semester as they get used to being in a new school, being in a new community. There's an additional domestic incident that is even more significant. So the charges against the parties were misdemeanors. However, Miss Farthing was charged with a felony domestic violence incident, and that case number is SU 2024 CR 235. It's my understanding that mom entered into a diversion on that charge as well, but that diversion did not occur until just a few weeks ago, January 21st of 2025. That charge was against her sister. Her sister has resided in the marital home off and on with the parties. Her father also has, and her sister has a history of drug use, including medication use. Her father also has a pretty significant history of alcoholism, and he has resided with the parties. So my client leaves the house in July, and then files for divorce. Miss Farthing enters into treatment, which we think is excellent, and hope that she maintains her sobriety. But the kids needed to be provided for at that time, and Miss Farthing continued to reside in the marital home. Mr. Farthing had to get a new home here in El Dorado, so the natural result of that was that Miss Farthing was assigned to the marital residence where she was living with her father and had been since July, when Mr. Farthing was excluded from the home by the police. And she had the payment obligations for that, starting with the temporary order. The mortgage was paid up until September. All utilities were paid through September, despite him having left the home in July. Not through September, but to September, so through August. And I think the parties have reached an agreement about selling the marital home, and I believe I'll be filing an agreed order for that to occur because neither party is living there, and I don't think the parties, either one of them, can afford to live there on their own and individually. However, it has been appropriate during this time and transition, and while Ms. Farthing dealt with her criminal charges, while Ms. Farthing went to rehab, for Mr. Farthing to be the primary parent. And he was here in El Dorado, so the kids went to school in El Dorado. The kids have regularly visited mom on the weekends, so we're not sure what these allegations about them not going are related to. The kids spent the majority of Christmas break with mom. And I think that Ms. Huntington and I will be able to reach an agreement on a parenting plan moving forward, and perhaps a divided residency plan allowing Seth, the younger child, to return potentially to mom's care, while Dane, the child that has a history of running away from mom's care, would continue to reside with Mr. Farthing. So we would ask the court not to modify parenting time at this time, but allow the parties to work towards that agreement relatively quickly. Related to spousal maintenance, Ms. Farthing has a history of working in the airline industry. She lives in the aviation hub. There is no reason that she's not employed, especially with veteran status. We know that her alcoholism has impacted her ability to have employment in the past, but at being clean and sober, she should be able to have a job. So we would ask that the court not make any spousal maintenance awards until she documents and demonstrates to the court that she is seeking employment in some way, or seeking some sort of VA benefits related to any reason why she's no longer in military service. Additionally, related to child support, if there's a modification in custody, obviously that will result in a modification of child support. The current support order is $305 a month. Ms. Farthing has not made any attempt to make any support payments. Mr. Farthing has been primarily responsible for the children, been paying their bills, been making sure that they're taken care of. So we would ask that the court just maintain the current support obligation. It is based on a minimum wage, imputing Ms. Farthing at minimum wage, the temporary order child support worksheet, which was filed when the court issued the temporary order.
And where does your client work?
My client works at Spirit, Judge. Ms. Farthing also used to work at Spirit.
And he's making how much?
He makes gross about $6,000 a month.
And I'm sure you filed the DRA.
We did, Judge.
How much he has left over. What's his rent?
And I don't think that was on the initial DRA because at that point he was living, it's $1,600 a month is what was allocated to rent.
Your Honor, he indicated on his DRA that his total left over was $5,828 a month.
Yeah, you make that a month. You don't bring that home a month. I got rent.
Well, the problem is that even if I order him to pay her $350 or $500 a month, whatever the case may be, she owes over $300 a month in child support that's not being paid. And ultimately that leaves her with a couple $100. Which may not even feed her, let alone the kids. So I'm not really sure what to do here.
Your Honor, I don't know if it's even necessary, but I mean, this was the status quo was they were married and she wasn't working.
I know
he
that
agreed with
there was a lot going on. I think her employment was affected by her issues. And I think she could have been working. This is not a displaced mother who stayed at home with their kids all during the marriage, and he took off and left her with nothing. I mean, she's had since August, knowing that they were separated, to get back to work and get some income. And I don't think just because she's not working, he should have to fully support her. However, at the same time, I do believe, Ms. Locke, even if this court doesn't order any kind of permanent spousal support, I am often inclined during the transition phase and divorce phase to provide for some temporary support until people get on their feet. The reality is she doesn't have a job. So I am going to order that he pay her $800 a month in spousal. I'm not going to modify the child support obligation at this point in time. And I'm not going to change the custody. I'm going to give you guys a few weeks to come up with an agreement, or I'm going to ask that the parties enter domestic conciliation. Ms. Locke, your client's probably going to have to front the money for that, but then I will order, as part of a judgment at the conclusion of the case, a portion be assessed to her. So it would just be to get the ball rolling. So that might give both of them motivation to work something out, as opposed to the cost of conciliation, if there is a common ground that's in the best interest of the kids that they can come to. Obviously, if they do come to an agreement to split the boys because they genuinely believe it's in their best interest, that's going to change the child support, and you have to redo a schedule. And at this point, I'm not going to impute more than minimum wage to her right now. I'm also not going to give her enough money from him in the way of spousal that she's comfortable enough with living with her dad that she doesn't have an incentive to get to work. Now, I do wholeheartedly understand when people are in recovery, that has to be their number one job and priority. And generally, people who are very selfish people by nature. But when they are in recovery, they have to be selfish to maintain their sobriety. So I understand that her employment is important, but I do think her sobriety and recovery is paramount. So I'm trying to weigh and balance all of that, frankly. And I'm just hoping that it seems pretty obvious to me this is not a reconciliation situation. There's been criminal charges and a lot of repercussions of them living together. And I'm pretty sure it's had an impact on the boys. So I think now they need to look at this as, how are we going to move forward with our own life and co-parent? I'm also disappointed, but for them, but I understand that there's probably not much equity. This is a $325,000 house. And if they sell it, may end up being sort of a short sale and foreclosure if they don't hurry up. So I don't think there's money that's going to come from that for the parties to transition, and specifically a mom to transition into her housing. And right now, when she has the kids, it has to be at her dad's house. So hopefully she can convince him, if he consumes alcohol, to not do it while she has the kids. Really not in her presence if he cares about her sobriety and recovery, but we're just at one of those situations where there aren't very many good answers here. But you need to just roll up your sleeves and get to work and see what the best scenario is for both of them at the least amount of money. So,
Your Honor, may I ask a
Ms.
question?
Farthing, do you not receive any benefits, VA benefits? Have you never filed a disability claim for them to rate you?
I have lawyers working on a full and complete disability for me right now, but it's been a very long process.
Okay,
The reason why I do not want to get back into aircraft is because I physically cannot do it anymore.
okay,
My hands, my wrists. That's why I'm trying to go to school to take up a new career.
okay.
And
All right,
that's-
we'll look at those things. Keep communicating with your attorney. Ms. Locke, would you journalize the sale of the house?
Yes,
And
Judge.
Ms. Huntington, would you journalize today's hearing?
Yes.
And then do you want to date in 30 days to see if you can't have some agreed parenting orders or notify the court that they're in conciliation?
Yes,
Yes.
Your Honor.
Yes, Judge.
One point of clarification I would ask, there is the mortgage on the house. Neither party is living in the house. What do we do with that?
I think that it's probably not going to get paid. That's what I'm saying. It's going to end up in foreclosure.
Okay.
And hopefully just an interim judgment, or they'll find a buyer real quick that they can do a short sale or figure out a way to maneuver a sale that would include them being able to get out from under their mortgage. I guess I'm not going to order either party to make payments on the house and just hope that it can be put on the market and sold quickly. Now you've got the whole other issue though of, is the water still on? Are the pipes going to freeze? Is there anything in the house that could, any animals or anything that could destroy the house? I mean, you guys could get hit with the deficiency judgment. And if the premises are deteriorating in any way, and that would not be beneficial for anybody. So I just don't have enough information to make all of the orders. I just think that we need to get the order to sell on file and see how long they can go without making payments on it. If they can sell it, if they can get out from under everything.
Judge, we would ask that the arrearage, the temporary child support arrearage, be reserved for future ruling, if that is appropriate and journalized in Ms. Huntington's journal entry.
Yes. All right, if there's nothing further today, let's just get March 13th. I have 2 o'clock.
Judge, I apologize. I'll be traveling the 13th through the 19th.
Okay. I could do the 12th, the special setting on the 12th, or I could potentially maybe do a special setting on the 4th.
The 12th would work best for myself.
I'm available on the 12th as well, Judge.
Okay, what time would you all like? I'm just busy between 1:30 and 3.
Would
Any-
this same time, 11 o'clock work, Tina?
Yes,
All right. Okay, I'll schedule the case for review at 11 o'clock on Wednesday, March the 12th.